Just go over here to that. All right, good morning. Welcome to the 294th District Court. My name is Judge Chris Martin. I'm going to call the docket this morning. When I call your name, please say present or here and raise your hand so I can see and hear you. What I'm going to do after I call the docket, we have visiting Judge Duncan Thomas with us today. He's going to take the first case. After that, counsel, I'm going to ask that you form a line over to the left so that we can take care of any business that's agreed. We'll try to move the docket quickly this morning. Tony Ray Curtis. Tony Ray Curtis. Nicholas Duberly. Nicholas Shane Duberly. Joshua Gamble. Jennifer Gathright. Kelly Gathright. Hannah Hampton. Shelton Vasquez. Tiffany Rankin. Damon Jackson. Thanks, sir. Glenn Smith. Paul Cohey. Thank you, Mr. Gamble. Melody Dollar. Reginald Young. Reginald Hoyt Young II. Thank you, Mr. Gamble. Quincy Hankins. Thank you, Mr. Warner. Holly Mormon. Thank you, Mr. Warner. Megan Bueno. Courtney Butler. Jose Perez. Jose Eulalio Perez. Thank you, Mr. Manning. Anthony Collard. J. Byron Riddle. Sarah Potter. Louise Leha. Thank you, Mr. Schminner. Zachary Duncan. Zachary Perry Duncan. Jamie Gant. Yeah, they're not on Zoom. Thank you, Ms. Heisel. Cleela Roden. Cleela Roden. Michael Watkins. Brandon Donahue. Misty Rice. Misty Michelle Rice. Leonard Williams. Brian Reyes. Marcus Gardner. Thank you, Mr. Warner. Jonathan Goodjoint. Wendy Jones. Thank you, Mr. Warner. Christian Pritchett. David Schaefer. Thank you. Rosman Shannon, Christopher Lapoma, Claudia Cook, John Lapano, thank you, Mr. Wood. We'll confirm that. Is there anyone's name that I've not called that's present in the courtroom? I've not called your name and you're present in the courtroom on today's docket. You ready? Okay. Because the defendant's going to be there. Just come on. That's good right there. Let me adjust this camera.
Mr. Gamal, come forward. Do you let them approach? All right, that's fine. He's fine. All right, sir, would you tell me your full name? All right, do you understand that the district attorney has filed a motion to adjudicate and revoke your community supervision?
Yes, sir.
All right, now I've been informed today that you have contacted an attorney, is that correct? And are you taking a record? Would you state on the record who that is?
I honestly don't know how to say it. So,
Can you spell it?
no, I can't. He's, I think he's like the Mitch Anderson, Tyler. He goes by Straw. I don't know his first.
All right, and your attorney or your prospective attorney did call the court and advise them that that he was going to be hired.
Right.
But he's not been hired at this point, is that correct?
I paid him last week, but it's on time again.
All right, so you believe that will be accomplished this week?
It should be, yes, sir.
All right. Ma'am, would you give him this, please? All right, Mr. Gamal, the state has filed an amended motion to adjudicate and to revoke your community supervision. And I have just had my bailiff hand you a copy. Have you received it?
Yes, sir.
All right. You need to advise your attorney that the state has filed an amended motion to adjudicate. Do you understand that?
Yes, sir.
All right. Under these circumstances, you claim that you are in the process of hiring an attorney. I'm going to set this case off for a hearing. And I'm going to set it for July the 19th. Pardon me. I think it's the 29th. Where is the coordinator? She stepped out. It's July the 29th at 9 o'clock. And I'm going to have the court coordinator notify your attorney of that date. Do you understand that? Now, if for some reason you're unable to hire this attorney or that doesn't work out, you need to notify the court by the end of this week. Do you understand that? And whether you hire an attorney or whether you don't, you'll have to be back on that July 29th date. Do you understand that? Do you have any questions? All right. Thank you very much, sir. You're free to go.
May I ask, is that for a contested revocation?
That's, yes, I'm sorry. Mr. Gamel, that's going to be the date of your hearing on the motion to revoke. We'll have an evidentiary hearing on that date. All right. Anything else?
No, thank you.
All right. Thank you very much, sir. You're excused at this point.
All right, council, are we ready, Mr. White? Are you first? Are you first in line?
I'm just here today.
Claudia Cook, CR 2153. All right, Ms. Cook is set for pretrial today. Go ahead.
Your Honor, I talked to Mr. Woodblack yesterday. I had a question about the investigation. I don't believe that his office had any documentation on that. He had indicated that if they had anything, I filed a motion for that they would get it, or I may have seen it. But if we didn't, I just have 30 days.
Any objection from the state?
No, Your Honor, that's the state.
All right, we'll reset this case to July 15th at 9 a.m. Ms. Cook, you're not free to go yet. Ms. Cook, I'm going to have Mr. White bring you this order. It's called TRN processing order. What this means is I'm going to need you to go out to the Van Zandt County Justice Center, to the jail, and present that to them so that they can get your fingerprints. All right, you were arrested out of county and they need to get your fingerprints so that they can get identification number for the state. So present that to them. They're just going to bring you in, take your digital fingerprints, and then release you. Okay, there shouldn't be a whole lot of waiting, or there's going to be no change out or anything like that. Okay, so I need you to do that upon leaving this court. Okay. Do I need a copy of it? Mr. Wright, will you give that to Ms. Wood and let her get a copy of it, and then she'll. Okay. Thank you, sir. Appreciate it. Mr. Manning, you next? Is this the line? Is it a sitting line? A sitting line? That's fine. It's too hot to stand anyway. Megan Bueno, CR 20-203. All right, we are set for pretrial today.
Yes, Judge, I filed a motion to suppress that case. Because of some documentation I was waiting on, I did not get filed till yesterday, so I don't know if you want to reset the pre-trial or we can go ahead and set it straight. After the trial.
Any objection by the state?
They may have not noticed, we're just setting it this morning, so.
All right, courts will set the motion to suppress on June 29th. That's 2 weeks. Is that enough time? 2 weeks?
That should be fine, it's actually in county warrant, so I'll need to check with the officers in that county, make sure it's okay, but I don't see any reason that would be available.
Okay, we'll set June 29th, and if we are unable to proceed that day, then it'll be July 29th. So,
Actually, Judge, I just realized something. I've been told that I may be number one downstairs, in the recent transfer case.
all right, let's set her on July 29th, and that'll give the state additional time with their out of county officers. And
Thank you, Judge.
yes, Courtney Butler. CR 2152, Ms. Butler is set for pretrial.
Yes, Judge. We have a pre-trial, we have the agreement work out, and it requires some forms up front. Ms. Butler has requested a 1-month reset with permission from the state. So we've got this.
All right, court will set Ms. Butler then on July 15th at 9 a.m. for plea. Yes. And you said no contact with Mr. Perez.
Because I was appointed, him, last month. I accepted contact with phone numbers I was given and then reached out to confirm that he knew about this.
Jose Perez. Jose Eulalio Perez. Thank you, Mr. Manning.
I believe it would be under this appointment.
Yes. Who's next? Are you ready on all of yours, Mr. Gimbel? Paul Cohey. CR 2152. Mr. Cohey set for pretrial today.
That's correct, Your Honor. We will go pre-trial.
All right, we will set Mr. Cohey then for docket call on July 15th at 9 a.m. And Mr. Cohey, I'm going to expect to hear on the 15th whether or not you want a jury trial, a bench trial, or you're going to enter into a plea agreement. All right, so I'm going to give you another 30 days for you to decide what you're going to do with your case. Make sure you stay in contact with your bondsman and Mr. Gimbel. And Mr. Cohey, I want you to report to pretrial release before you leave this morning. All right. Yes. Once you meet with pretrial release, you can go. Melody Dollar, CR 21-111.
her name is spelled correctly, and she understands.
All right, court will enter Ms. Dollar's plea of not guilty into the record. We'll set this for pretrial on July 15th. All right, Ms. Dollar, once you sign this notice, resetting your case till July 15th and receive the yellow copy, then you'll be free to go. You're free to go. Is Reginald Young here? Reginald Hoyt Young, the second. Right, is that all you have today? This one, you have some this afternoon? Do you have any this afternoon?
Yes, I do.
Okay. All right, we'll see you then. Who says that? Is that Mr. Chuck? Upon Oklahoma? Nope. Yeah. Oh, he does. Okay. All right. Do you have Reyes? Is it Reyes? Who do you have? Hannah Hampton. CR 2390, Hannah Marie Hampton. All right, we're set for pretrial today.
Yes, sir. If you'd like to retrial, and if you can't reset it, for me, this last week I had that.
So typically the way that I run the dockets here is we'll go from arraignment to pretrial. If there are no requested pretrial issues like motion to suppress, motion to quash, there's no evidentiary matters that need to be taken up pretrial, then what I do is then set it for docket call. And that's that time in which I ask the defense and the state to work together to determine if there's going to be a resolution. And then if not at docket call, then we can announce, requests for jury trial, bench trial, or plea agreement. All right, so we'll reset Ms. Hampton then for 30 days for docket call. Court will find there are no contested pretrial matters. And we'll set that July 15th at 9 a.m.
Thank you.
You're welcome. Miss Hampton, I'm gonna have an order brought to you that I need you to go to the Van Zandt County Jail after court to get your fingerprints processed, okay? So I'm gonna sign that and we're gonna have that brought to you. So before you leave, make sure you get this TRN order, okay? So if you want to, just have a seat in the hallway, and then we'll have that brought to you. You're welcome.
She gonna be able to come back to you.
Does she need to come back?
Yeah, well, I need to talk to her back. Is she gonna go down? Can I talk to her?
Well, the jail's not here, so I just had her sit in the hallway so she could get that order, and then she's free to go. So if you want to talk to her outside, then you can do that, or, yeah.
Thank you.
Yeah, I just had her sit in the hallway so that my staff could come around and meet her there rather than going back through here.
Thank you.
You're welcome. Mr. Wells, are you ready? Rosman Shannon, CR 2363. Yes, sir, please.
Here's the probation condition. We just got right forward. You called Docket, and so he's been through them, but I'm gonna go through them with him again.
Okay.
Page, they've got Rosman with an S instead of a Z.
Should be with a Z. All right, Mr. Shannon, I'm going to ask that you raise your right hand so I can place you under oath. Mr. Shannon, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you put your hand down. Your name is Rosman Renee Shannon, is that correct? And do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? Have you ever been diagnosed with any type of mental condition? What have you been diagnosed with? PTSD? Are you currently undergoing any type of treatment or on any medication for PTSD? Okay, you're taking medication. Are you on medication today? Do you feel like the medication is helping you with your PTSD? Feel like you have a rational understanding of everything that's going on here in court today? In this case, you're represented by your attorney, Mr. Ron Wells. Are you pleased with Mr. Wells' representation of you? Do you feel like you've had enough time to be able to talk with him about your case and have all your questions answered? Anything about the paperwork that you've read and signed that you don't understand? Mr. Wells, do you believe Mr. Shannon to be competent today? And his diagnosis of PTSD, do you believe that in any way makes him incompetent or unable to understand the proceedings? All right, Mr. Shannon, you're charged by indictment with a third-degree felony offense of assault of a family or household member by impeding breath or circulation. A third-degree felony in the state of Texas carries a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice and an optional fine not to exceed $10,000. If the court approves the plea agreement before it today and places you on deferred community supervision, if the court finds that you violate the terms and conditions of your community supervision, the court could revoke your community supervision, adjudicate your guilt, and assess punishment anywhere between 2 years and 10 years. Do you understand that? Understanding that, you still want to go forward with the plea? All right, Mr. Wills, have you explained to Mr. Shannon the advantages and disadvantages of a deferred adjudication plea? And you've explained to him his legal and constitutional rights? All right, Mr. Shannon, then, understanding the charge and the range of punishment, how do you plead to that third-degree felony offense? And are you pleading guilty because you are guilty of committing that offense and for no other reason? Has anyone threatened, forced, or pressured you to plead guilty today? All right, court will accept the defendant's plea of guilt at this time. Mr. Wells, any objection to states one? States one is admitted. The court takes judicial notice of Mr. Shannon's judicial confession. Anything further from the state?
Your Honor, the state would like to put on the record that we are in compliance. Have no response from the victim. It's the same victim in both cases. No response from her. However, the state has consulted with CPS, who's involved in this, and resolution with she, as well as with you, Mr. Shannon. The incident records, and that's the work with representation today.
Thank you, Ms. Heisel. Anything from the defense?
Judge, there's one more thing, motion to dismiss on that case, is that before you?
Yes, I have seen it. It's not part of the plea agreement, however, but it has been tendered separately.
As long as you. It's,
And that's CR 2364.
Yes, Your Honor, we'll vote on that.
If I may, Judge, it was discussed as part of the plea agreement, I may have failed to write it in the handwritten part, but you would.
That's correct, Your Honor. Taking the vote together. There are witness clinical allegations in case that there's a very first dismissal. And that's why we're proceeding on to that.
Okay. All right, based on the court's review of the evidence, I do find that there is sufficient evidence to convict Mr. Shannon of this offense. The court will follow the plea agreement in this case. The court defers a finding of guilt, places the defendant on 5 years deferred community supervision. Court assesses a $2,000 fine, orders the defendant to pay $290 court cost and $40 reimbursement fee. All right, Mr. Shannon, I'm going to commit you to the custody of the Van Zant County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm going to have you step forward to be fingerprinted by the deputy, and then after that time, I want you to go through this door and meet with probation. Yeah, we did, but they just weren't here at 9 o'clock. Is that all you have, Mr. Wells? Yes, sir. Thank you. Mhm. Last one on which page?
Summer cold.
There's no proper possibly this moment for home hearing, no rest, set the docket call.
We available on July 15th,
So I think, yes, Your Honor. 9 a.m.
9 a.m. Yes, sir. When she signs that and gets the yellow copy, she'll be free to go.
Thank you, Your Honor.
Louise Leha, CR 17204. All right, Mr. Leha set for motion to revoke.
Yes, sir. For 6 years. And
Yes. Yeah, so give me some update on Mr. Leha. I mean, I see that he got put on probation, never reported, never did anything.
Ms. Craig reached an agreement and she wanted him to pay up everything he owes and report to probation officer, start his community service, his classes. And he's done with that. It's gone up $1,000. Current on all costs, current relations.
So Mr. Leha, this time's gonna be different? Is this time gonna be different? How so? What about reporting? Because you never even reported. Promises are only good if you follow through with them. You understand that? As I look at your paperwork, to me, you don't look like a good risk. Now, Mr. Smithers has told me that you have made great strides in coming up with money and paying your delinquencies and doing your classes. And I'm assuming, have you done your community service also? All right. So do you understand that this court, if you don't have money, that's one thing. But if you fail to show up and make an effort, that's another. One of those I'm going to look on more harshly than the other. If you show up and you say, I'm doing my community service, I'm reporting, I'm not drinking alcohol, I'm not doing drugs, I'm doing everything I'm supposed to, I'm just coming up short because it's hard financially. I don't send people to prison because they can't pay. You understand? All right, court will grant the state's motion to withdraw, the state's motion to adjudicate, and sign that order today. And court will approve the amendment to the conditions of community supervision. This needs to go. This is Mr. Leha, so we'll give that to him. So, all right, Mr. Leha, I've signed that. I want you to come over and meet with probation before you leave, okay? Thank you, Mr. Spinner. Yes, sir. Mr. Sanders, are you ready? Sarah Potter. CR 21-138 set for arraignment today.
Yes, Your Honor. And Judge, we got a copy of these documents, her name is spelled correctly, and then we've got over the punch range for the jail cell in charge. We waive the reading of these documents, waive the formalities of arraignment, and enter the plea of not guilty.
All right, the court will enter Ms. Potter's plea of not guilty into the record. We'll set this for pretrial. Remind me your schedule, Mr. Sanders. Aren't you out a little bit in July?
No, Chief, it's in the end of this month.
End of this month?
Really, it's not July.
Have you already received access to discovery in this case?
No, not yet.
All right, we'll set Ms. Potter on July 27th. Give you time to get discovery, review the DWI video. July 27th at 9 a.m. for pretrial. And Ms. Potter, before you leave, Mr. Sanders is going to bring you this yellow notice that you've signed. After that, I need you to report to pretrial release to sign some conditions of pretrial release paperwork. Is that all you have on the morning docket?
Yes.
Plenty to do this afternoon, huh? Mr. Weiner, are you ready?
Yes, Your Honor, a few of them. It's okay, I start with
Mr. Hankins. CR 20-121. Set for docket call.
Yes, Your Honor. I'm not sure if they were assigned and finding back choosing the role in this case. I know they were attended by the state. If they were assigned, I'll get a copy of those. So that's what I'm calling.
Yeah, I believe I did.
Okay,
And I'll double check.
maybe it's not a copy.
Yeah, they were signed in e-file on April 26th at 4:24.
Great, I will get a copy of it. Or that was just the only housekeeping matter I think we asked. Just asked to be placed on the.
Child docket. All right, so what's been the offer in this case? It's been rejected.
At this time, there is no offer.
There actually is. I previously revoked, previous offer and have re-extended 2 years probation, probation.
That one is fine as well. I thought it's great. Something else.
Oh. That may be subsequent.
But regardless, we wouldn't take a straight probation on this case, so we would reject that.
So the offer was 2 years probated for 3.
Yes, right.
All right. All right, court will place Mr. Hankins then on the jury selection docket beginning June 21st. And so, Mr. Hankins, you'll report down to the basement of the courthouse on June 21st at 8:30. Mr. Weiner and Mr. Head will not be required to be there until your case is noticed for the top 10. So when you get to the courthouse, 8:30 in the basement, then my staff will be down there and they'll assist you with paperwork and get you on your way.
I'm getting some reason for that.
And Mr. Hankins, before you leave today, I want you to report to pretrial release. I show that you didn't report last month. So I want you to report to pretrial release. Holly Mormon, CR 16139.
Good, I don't see her present for Lorraine. We documented that she was in Nexus, and I had to engage my client that she's not to some sort of sober living environment. I don't have any documentation from her about that, but I don't expect her to report today. It's my understanding, but I don't have documented proof of it, that she's continuing to report, right?
That's actually not correct, Your Honor. Ms. Mormon was set out on leave April 15th. Probation received notification that she was released. We did have documentation that she was in, and then she was released 2 days before, but we didn't believe at that time she had proper notice. We did not put her out for that time. However, the state would ask for one today, considering we reset her for that purpose, and she's still not here to support. And we've not heard from her whereabouts.
Not sure what was a direct asset, but I was just reading what states that.
But you said you believe she's in a sober living facility and you're saying you don't believe she's in a sober.
I received an email from the person who runs the house. So it's not next. I mean.
I believe so.
Makes
That's
sense.
the only information we had is that she was released from Nexus.
Right, and it's my understanding she's no longer in Nexus, obviously, she's somewhere else. I saw the documentation.
Where do you believe that she's at? Like location and name?
Very, very little information. I received a name from, or an email from I received an email from Cindy Dunn. I have no information about what facility's name or anything. I don't want to search name in the report, but that's not very little documentation or anything else in a couple of emails, but I did want to at least put that on the record in case the board.
Holly Elise Mormon. All right, court, we'll have her name called in the courthouse loudly, distinctly 3 times. And if she doesn't make an appearance in the court, we'll issue a judgment not signed, forfeit her bail.
If I'm able to try and get her on via Zoom before the day's over, is that something that we'll consider?
May consider, yes.
Okay.
No guarantees though.
I understand. I'll do my best. Okay. Then on SC5, Marcus Gardner.
Marcus Gardner, CR 161 and 162. All right, set for a docket call today.
Yes, Your Honor, we have an agreement in this case, this is for what call center complex, you know, different other markets Gardner, whether or not you've been in prison multiple times once. We have sorted all that out, have an agreement. However, the state is requesting that we verify that the firearm that was found in the vehicle belongs to Mr. Gardner's wife. I spoke to his wife was present for she that documentation. We have a waiver of jury trial, as you say, and we like to set it for sleep, so we do that documentation the same.
Do you know about how long you need for plea?
I would say standard 45 days. Around there.
And Judge, Mr. Gardner, our agreement is 4 times, so we ask that we set it at 1:30 jail docket. We have no objection to 30 days for the documentation. of the agreement.
You have the waiver of jury trial.
Yes, I do. Can I approach this?
You may.
We had previously done the waiver. We had previously printed it. Mr. Weiner and I both thought it was previously been executed, however, it did not show up in the clerk's file. So we thought we'd redo it just in case.
Okay.
I think the issue was because we weren't sure about the prior judgments, whether that was, you had 2 trips or 1. I didn't want to do a waiver and we weren't sure what the punishment was, and that's why we didn't execute at that time, but I'm comfortable now that we sort all that out.
All right, Mr. Gardner, if you'll raise your right hand, I'm going to place you under oath. Mr. Gardner, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? Say it loud so my court reporter can type it down. All right, you can put your hand down. All right, you are Marcus Dwayne Gardner, correct? Mr. Gardner, I have in my hand 2 documents in each one of your cases, both the same document that say waiver of jury trial. Have you gone over this with your attorney, Mr. Weiner? Do you understand that you have the absolute right to have your case tried before a jury of your peers? You understand that no one can deprive you of that right? You understand that if you waive that right, you would also be waiving the right to contest and confront the state's evidence before a jury. You understand that once you waive that right to a jury trial, that there's very limited circumstances in which it can be restored to you. Has anyone pressured you to waive your right to a jury trial today? Understanding that you have that absolute right and that no one can deprive you of that right, are you asking the court to allow you to waive that right today? Are you doing so intentionally, knowingly, and voluntarily of your own free will in a court? All right, the court will find that the defendant has been admonished as to his waiver of jury trial and has intentionally, knowingly, and voluntarily waived that right. The court hereby approves the waiver of jury trial in each case. We'll set Mr. Gardner then. Are you available on July 13th, Mr. Warner?
I'm heading out of town the very next day, so I think it's possible, but if you have something like the week of the 19th or 26th, that'd be better. No,
We could do July 27th if there's no objection by the state.
that's fine. I think that
Is that a scheduled document, Mr. Honor?
Yes.
No.
All right, we'll set Mr. Gardner then for plea on July 27th at 1:30 at the Justice Center. And then, Mr. Gardner, I need you to report to pretrial release before you leave today.
So, right here. It's not one, so that's not one.
And then on the next page, Wendy Marie Jones.
Wendy Marie Jones, CR 13368, CR 21129. Ms. Jones is not present in the courtroom.
That's correct, Judge. I did furnish Ms. Thompson and say documentation she had from the doctor saying she was not released to work or school. Testing that she informed me yesterday that she was still symptomatic. She's not present.
When did she have the COVID test?
The letter was dated June 8th, so last week, Judge. I checked with her yesterday afternoon, to see if she had received results, and she told me she hadn't received results.
All right, so what I'm gonna do is I'm gonna issue a judgment nisi and alias capias, and if her results come back where she's positive, then you'll notify the court and I'll have that warrant withdrawn.
Okay. Do we want to go ahead and get her a reset date?
No.
We just want me to report the results in this conference in the state.
Mhm.
Okay, that's all.
And then you're still working on your other ones. Good joint. Okay. Swipe, Rick. Christopher Lapoma, CR 2125.
That I am probably 99% sure we are done with accepting. If we could just have a come back.
So you want to set it for plea? All right, we'll set Mr. Lapoma for plea on July 13th.
Saturday is Tuesday or, sorry,
It's a Tuesday
oh, that's good.
until Monday Night Football. And I will need Mr. Lapoma to meet with pretrial release before he leaves today. John Lapano. Yeah, we're going to put that on the record. CR 2396, Mr. Lapano has been confirmed in the Cameron County Jail. So we will reset. Mr. Lapano, are you available on July 13th? Okay. Ma'am, I'm gonna need you to step out if you're wearing shorts. It's on the sign right before you walked in the door. All right, we're gonna reset Mr. Lapano for a status and docket call to July 13th at 9 a.m.
Judge, I'll try to be patient with him or his family. Check our steps.
Thank you, sir. And if you want to stick around a little bit, once I get through calling, we may be able to meet on this afternoon. Mr. Tibolodi, are you ready? Brian Reyes, CR 2305. You want to set him for a plea?
Yes.
How long do you need? Leave July 13th. It's a Tuesday. Is that fine? Is it Thursday better? If it's, yeah, that's fine. That's fine. Okay, we'll set Mr. Reyes in for plea before the court on July 15th at 9 a.m. Mr. Reyes, once you sign this notice and get the yellow copy, you'll be free to go. You're welcome. Who's your client? Damon Jackson. You'll just make your way to the podium. All right, let me call the case real quick. CR 2122, CR 21173, State versus Damon Drake Jackson, set for pretrial on the assault public servant and arraignment on the assault family violence. Go ahead, Mr. Forey.
We discussed this new case, bonds, we're retained on that now. We have filled out the agreements arrangement, we put date on that is 7/27, that's with support. And I don't know if you give me a copy of what we discussed that, not that I'm here.
So you've gone over the indictment with Mr. All right.
You've got a copy of it.
Yeah, I have the original here, so. All right, so what we'll do is we'll set Mr. Jackson then for pretrial in each case on July 27th at 9 a.m. And once Mr. Jackson signs that notice of appearance and gets the yellow copy, he'll be free to go. Yes, just put both cause numbers at the top.
Thank you.
Welcome. You're free to go, Mr. Jackson. Glenn Allen Smith, CR 2192, 2020-592. Mr. Smith is set for pretrial in each one of his cases.
Yes, sir, I believe. My recollection is what's in our, first time both cases, then I'm swapping. We have a transfer pool. Here we are, with them together, I've been asked to be the pretrial. On the second day, 7/27. Discuss that with the prosecutor.
All right, court will set Mr. Smith for an additional pretrial on July 27th at 9 a.m. in each case.
So we have the same day,
7/27 at 9 o'clock. Yes.
maybe.
Yes, sir.
Thank you.
You're welcome.
Good morning, Your Honor.
Good morning, sir. How are you?
Good. And you should have.
I've got one, I understand. I've got one other attorney that I'm gonna call before you and brought you in. So,
No problem.
Mr. Knoll, if you're there, if he doesn't chime in real quick, then we'll move on to you. Oh, I know you chime in real quick. Mr. Knoll, I'm not sure you're connected to audio. All right, while Mr. Knoll's working on his unmuting, I'm gonna go ahead. All right, let me bring in Ms. Gant.
While you're doing that, Your Honor, I think we have reached a plea agreement, so we'll be setting up for plea in person next setting.
All right, I'm just gonna ask you to unmute that, Mr. Duncan. You'll just unmute that. Just click that red microphone.
Okay.
Just one second. All right, this is call number CR 2384, State versus Zachary Duncan, and CR 2386, State versus Jamie Gant, set for pretrial today. Mr. Staub, you had made a previous announcement. I don't think that your clients were in here. If you'll go ahead and make that announcement again.
Yes, Your Honor, the state and the defense have come to plea resolutions with both cases, and so we'd like to set up for a plea on the docket.
Okay, how much time are you requesting for a plea?
Your Honor, you tell me what this court normally does and we can help out. I don't know what the normal process is in this court. I'm sorry.
It's okay. Are y'all trying to pay fines and fees or anything up front? Are you trying to collect money? Is there a certain time?
It's gonna be a couple days in jail, but yes, a fine over probation period of time. It's gonna be a misdemeanor reduction on one case and a dismissal of the other case.
What about July 6th?
Hold on one second. That works for me, Your Honor. Is it possible to do an afternoon since we'll both be driving in? They'll be coming from Louisiana and I'll be coming from Dallas. Or
Did you say that there was going to be some jail time as a condition?
yes, we're still negotiating how long depending on the fine, but yes.
Yeah.
Now,
So
we may not do it we've been given the option to do it a different weekend versus that day. We're going to talk to my client about that. So.
well, our afternoons are reserved for jail dockets. If your client was going into custody that day, then we could do it in the afternoon. Otherwise, all the afternoons are reserved for my jail docket. We do bail
Okay.
and jail in the afternoon. So,
Let's post it in the morning then, just for now. And if I need to move it, is that possible?
yes, I'd rather go ahead and nail it down now rather than creating more work later. So
Is there a way you can put me can I have 2 minutes to talk to my client real fast?
yes, let me create a breakout room and I'll put you there.
All right, thank you.
So whenever you're prompted to with an invitation to join the room, you'll need it, Ms. Gann and Mr. Duncan. Mr. Sanders, you ready? You ready on Vasquez? CR 1878, Shelton Vasquez. All right, Mr. Vasquez is set on a motion to adjudicate. Mr. Vasquez has requested court-appointed counsel. The court has reviewed his application for court-appointed counsel based on indigency. The court finds him to be indigent at this time with ability to reimburse. Court has appointed the Honorable Jeff Sanders to represent Mr. Vasquez. Mr. Sanders, have you had an opportunity to meet with your client this morning?
Yes, sir, we have talked briefly. If I do have a copy of the motion to revoke, I would ask for some time on this state.
All right, court will set Mr. Vasquez on the contested docket on July 29th. That'll be at 9 a.m. Mr. Vasquez, you're still on community supervision, still required to report, pay, do everything I've ordered you to do. Okay, failure to do that could result in the state filing an amended motion. They could bring additional violations against you, okay? Once you sign the yellow copy, I want you to check in with probation and then you'll be free to go. Mr. Steele, are you ready? You ready on all of yours?
No, I got more coming. Want to do both at the same time?
You got, say that again?
I have 2 points. One's ready and one's.
Oh, yeah, we'll just wait. We'll wait and we'll knock them off at the same time. Mr. Weiner, are you ready? Okay, that's fine. That's fine. I was just checking. Mr. Knowles having problems logging in. And we'll we're waiting on Mr. Staub as well. Leonard Williams. Can you give me one of those notices settings, please? Fill it out. Mr. Williams, have you been in conversation with or communication with your attorney, Mr. Bill Stevens? All right, Mr. Stevens filed a motion for continuance today. He's in trial in Kaufman County, so I'm just going to reset your case. All right, when's the last time you spoke with Mr. Stevens? May the 4th? All right, Mr. Williams. Deputy is going to bring you this form. Just sign there on the X where it says defendant. Your reset date is going to be July 13th at 9 a.m. Once you sign this, we'll give you the yellow copy and then you'll be free to go. And I want you to contact Mr. Stevens. Brandon Donahue. Mr. Donahue, is going to be the same announcement. In your case, I'm going to reset you to July 13th. When's the last time you've been in contact with Mr. Stevens? Are you not contacting him outside of court? No, I understand that. I'm saying, are you not communicating with him outside of court? You're not calling his office or not talking or anything? Y'all just only meet in court? I show that you were set to plea today. Is that right? Makes me uneasy that we're set for plea today and you don't know what the status is and what the resolution is. Doesn't evoke a lot of confidence in me. I want you to sign where it says defendant. You're gonna be back on July 13th. Guess we'll both learn on that day what happens. Free to go. Is Misty Rice here? All right, Ms. Rice, if you'll step forward. Ms. Rice, I called your name at 9 a.m. You didn't answer. Were you here at 9 a.m.? Well, I wrote down on my docket to issue a warrant for your arrest. Do you want me to do that? I'm going to reset you to July 13th at 9 a.m. Mr. Stevens is in trial in Kaufman County and he filed a motion for continuance and the court granted that. But I want you back on July 13th at 9 a.m. I don't have a phone. So I looked down, I thought you were filling it out. All right, Ms. Rice, sign here. We'll give you the yellow copy and then you'll be free to go. And Ms. Rice, actually, I want you to report to pretrial release before you go. After you get your yellow copy, report over here to pretrial release and then you'll be free to go. All right, Mr. Staub, are y'all ready?
Yes, Your Honor. We're gonna take that July 6th in the morning.
Say that again.
We're gonna do the July 6th in the morning.
Okay. All right, so the court will set Mr. Duncan and Ms. Gant on July 6th at 9 a.m. Enter the plea before the court. And so, Mr. Duncan, Ms. Gant, this will be the only notice that you get from the court here in open court, okay? July 6th, 9 a.m. Free to go.
Thank you, Your Honor.
You're welcome. You have a good day.
You too.
You ready? You back? Christian Cecil Pritchett, CR 19-153. It's a hearing on the motion to revoke.
Yes, sir, we have agreement. Yeah, approaches, essentially, we're modifying, to essentially equal this back time. Crux of the motion, was a new allegation of early verification, which the state vetted is going to decline. So we're essentially leaving him on, just even wait back time.
Correct, Your Honor, that new burglary charge was arrested in October. The state has still not received a case from the arresting agency, so I'm taking that as they are dropping the charges. However, if they do bring that to our office, we are agreeing at this time not to proceed on that.
Has the state requested the offense report?
The cop requested that case, that's how long they've been after it.
And we did not get the offense report of the new charge. I have reviewed that, but they didn't tender us the entire case. I actually got that offense report from probation because multiple attempts to contact the arresting agency went unanswered. I have spoken with other law enforcement agents in the county that are familiar with the actors in this case, and we believe this is the best course of action going forward.
All right, the court will grant the state's motion to withdraw. The court will also approve the amendment to the conditions of community supervision.
There's also new work costs from, space office that we had. So. That's one next one.
All right, Mr. Pritchett. Where are we gonna go from here? You, huh? Back to work? What about you and I? Where are we gonna go from here? You're gonna go back on probation? You coming back to court? You don't plan on it? All right, I wouldn't plan on it either. All right, courts granted the motion, signed the order and the amendment to the conditions. Mr. Pritchett, come back here and meet with probation and you'll be free to go. Okay. All right, we're gonna try Mr. Knoll again. Curtis having some kind of trouble. Get what he's in. Do you wanna? And maybe you can just call to the Zoom line. And then I can put him on audio, that way his clients can hear him. If I put him on speakerphone, they're probably not able to hear him. All right, thanks. I don't want you to approach, but Anthony Collard and Byron Riddle, Mr. Knoll is trying to get logged in via Zoom and he's having some difficulty. So in just a moment, we're going to try to work around that and I'll get your cases called, okay? Is Tony Curtis here? Mr. Curtis, if you'll approach. Mr. Knoll, are you there? Mr. Knoll?
Hello?
Yes, Mr. Knoll, can you hear me? It's Judge Chris Morton.
I can, Judge. Sorry about all the technical stuff. I couldn't hear
Hey.
you before, and I know you couldn't hear me.
Yeah, that's right. Okay, this works out better. Okay, I'm gonna call your cases real quickly and get you gone, okay?
Thank you.
CR 21-110, State versus Anthony Dale Collard for arraignment. Mr. Collard is charged by indictment with a prohibited weapon, a third-degree felony. Carries a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice and a fine not to exceed $10,000. Have you had a chance to meet with Mr. Collard and go over the indictment with him, Mr. Knoll?
Judge, we've had a chance to talk over the phone about what the charge was. I know that his name is spelled correctly, and we actually even talked about the weapon. So I think he understands the charge. For the purposes of arraignment, we would enter a plea of not guilty.
All right, court will enter Mr. Collard's plea of not guilty into the record, and we will set this for pretrial. Do you have your calendar available, Mr. Knoll?
I've got something ready, Your Honor. Go ahead.
Okay, I've got a couple dates, either July 13th or July 15th.
15th, probably good, Judge.
15th. All right, we'll set then Mr. Collard for pretrial on July 15th at 9 a.m. I'm gonna have him sign a notice of appearance and then he'll be free to go.
Thank you, Judge.
All right, Mr. Riddle, if you'll make your way to the podium. All right, this is cause number CR 2355, CR 2359, State versus J. Byron Riddle. We're set for docket call today. Go ahead, Mr. Knoll.
Judge, Mr. Riddle, I think the last time his case was up, he was in the hospital. He has not had the opportunity to get to my office yet, and I got a fairly lengthy statements from several individuals about the case that we just need to go over and compare that with the discovery. If we could have one more pretrial, I think we can figure out what we're going to do.
Any objection from the state? If you want to take a moment to review. All right, court will reset Mr. Riddle then for an additional docket call on July 15th at 9 a.m. Mr. Riddle, have you signed this notice of appearance and then you'll be free to go, returning on July 15th, 9 a.m. All right, thank you, Mr. Knoll. That's all you got, correct?
Thank
Appreciate you,
I
sir.
believe it is. Thank you.
All right, have a great day.
Bye-bye. Thank you.
All right, Mr. Steele, are you ready?
Yeah, okay, so ready to-
Okay. All right, Clelo Road in CR 2357. All right, Mr. Roden, if you will, raise your right hand. I'm going to place you under oath. Mr. Roden, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can put your hand down. I noticed that on the judgment in the terms of the plea, there's an X right here. Does that signify anything to either one of y'all? Just so I'm clear. The very end, it just says X. I don't know if that's a
I think
time,
that's a typo.
just a typo. Okay. All right, Miss Roden, are you Cleela Roden? And Miss Roden, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Kyle Steele. Are you pleased with his representation of you?
Yes, sir.
Do you feel like you've had enough time to talk with him about your case and have all your questions answered?
Yes.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No,
Mr. Steele, do you believe your client to be competent today? And you've explained to her legal and constitutional rights and also the advantages and disadvantages of a deferred adjudication plea? All right, Ms. Roden, you're charged by indictment with a third-degree felony offense of possession of a controlled substance in penalty group 1, greater than or equal to 1 gram, but less than 4 grams. That carries a range of punishment of not less than 2 years or more than 10 years confinement, the Texas Department of Criminal Justice, and a fine not to exceed $10,000. If the court approves the plea agreement today and places you on deferred community supervision for 3 years with a fine and restitution, if the court finds later that you, upon a hearing and evidence that you violate the terms and conditions of your community supervision, the court could adjudicate your guilt, convict you of the offense, revoke your community supervision, and assess your punishment anywhere between 2 years and 10 years in prison. Do you understand that? Understanding that, do you still want to go forward with the plea? All right, Ms. Roden, then to the third-degree felony offense of possession of controlled substance, how do you plead? You pleading guilty because you are guilty of committing that offense?
yes,
Has anyone threatened, forced, or pressured you to plead guilty?
no,
All right, court will accept the defendant's plea of guilt. Mr. Steele, any objection to states 1?
No.
States 1 is admitted into evidence and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state, from the defense? All right, Mr. Roden, I've reviewed the evidence and I find that there is enough evidence to convict you of this offense. The court will follow the plea agreement in this case. The court will defer a finding of guilt, place you on community supervision for 3 years, order you to pay a $2,500 fine, $180 restitution, $290 court costs, and $35 reimbursement fee. Mr. Roden, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department, so they can carry out the terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted with the deputy. After that time, I want you to report to the officers here with the probation department. Michael Watkins. All right, Mr. Watkins, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you put your hand down. Mr. Watkins, are you a United States citizen? Do you read, write, and speak English as well? Have you ever been diagnosed with any type of mental condition? You're also represented by Mr. Steele. Are you pleased with his representation of you? Feel like you've had enough time to discuss your case with him and have all your questions answered? Anything about the paperwork that you've read and signed today that you do not understand? Mr. Steele, say again. Did you say something? Okay, I'm sorry. I thought you said something. Mr. Steele, do you believe your client to be competent today? You've explained to him his legal and constitutional rights. All right, Mr. Watkins, you're charged by indictment with a third-degree felony offense of evading arrest or detention with a vehicle, which carries a range of punishment of not less than 2 years or more than 10 years in TDC and a $10,000 fine.
State is-
Okay. I see here that the plea agreement that you want the court to approve is that you would plead guilty in exchange for the state's recommendation that your punishment be assessed at 10 years confinement in the Texas Department of Criminal Justice, with that being suspended and you being placed on community supervision for 4 years with a $2,000 fine. And the state would also be asking the court to consider and either reject or dismiss 3 separate cases: duty on striking a fixture, highway landscaping, another evading arrest or detention, misdemeanor, I believe, and also a criminal mischief. Understanding that full range of punishment in the plea agreement, is this what you want the court to approve today? All right, so Mr. Watkins, then how do you plead to the third-degree felony offense of evading arrest or detention with a vehicle? Are you pleading guilty because you are guilty of committing that offense? Has anyone threatened, forced, or pressured you to plead guilty today? All right, court will accept the defendant's plea of guilt at this time. Is there still any objection to states 1?
No.
All right, states 1 is admitted into evidence. The court takes judicial notice of the defendant's judicial confession. Anything further from the state? From the defense? All right, court's reviewed the evidence and the court will follow the plea agreement in this case and the state's recommendation. Court hereby convicts Michael Watkins of evading arrest or detention with a vehicle, third-degree felony. Court assesses his punishment at 10 years confinement in the Texas Department of Criminal Justice. The court will suspend that sentence and place Mr. Watkins on community supervision for 4 years. Court assesses a $2,000 fine. Court also takes into consideration under section 1245, DA 2020-396, DA 2020-394, DA 2020-397. Court also orders Mr. Watkins to pay court costs of $290, reimbursement fees of $55. Mr. Watkins, you've been on community supervision before? Did you successfully complete it? What do you think about this one? What's going to happen if you don't take care of it? Well, tell me, let's be more specific than big trouble, because big trouble to you and big trouble to me, they might mean different things. What about as far as your liberty? What have you agreed to do today? What have you agreed to do? Well, you agreed, and I agreed. We made an agreement today, right? I agreed to follow this recommendation. You agreed to go to prison for 10 years if you don't do your probation. That's what you've agreed to do. So if you violate it, then a deal's a deal, right? You're gonna come in and you're gonna go to 10 years in prison. Okay? So I suggest that you get over and you meet your probation officer and figure out what it is you gotta do to be in their good graces. Okay? Otherwise, next stop, TDC. All right, Mr. Watkins, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm going to have you step forward with the bailiff to be fingerprinted. After that time, I want you to report to the probation department.
That's all I have.
Yes, thank you, Mr. Steele. Sweeney? Who do you have? CR 2188, Jose Perez. Mr. Perez, I called your case at 9 a.m. I was here, Mr. Manning was here. You were not here.
Yes, sir. I got up at 5 this morning, I work night shift, and I overslept. I mean, my brother don't call me, and I'm gonna go there.
Any reason that I shouldn't just go ahead and put you in custody now so that I can make sure that you get here on time?
You know, I just hope, you know, chance for me, maybe I'm up here. Like I said, I overslept, I worked till 5 in the morning, I've been working 12-hour shift. Shut down, I was.
All right, Mr. Perez is set for arraignment today.
Yes, Judge, we've gone over his indictment. You understand the charge against him. His name is spelled correctly at this time. Please not good.
All right, the court will enter Mr. Perez's plea of not guilty into the record. We'll set this for pretrial. Are you on vacation or have any vacation letters into the court for July?
I have one, I've emailed the court coordinator for July 5th and 6th. But other than that,
All right.
I believe the previous date that was given was July 15th.
You fine on that date?
I've already gone over the discovery. I should speak my mind about it.
Okay. All right. Court will then set Mr. Perez for pretrial on July 15th at 9 a.m. CR 21-118, Kelly Gathright. All right, Mr. Gathright, you're set for arraignment also on manufactured delivery of a controlled substance. Penalty group 1, 4 grams to 200 grams, first degree felony, carries a range of punishment of not less than 5 years or more than 99 years, or a life confinement in TDC and a $10,000 fine. Do you intend to hire an attorney to represent you on this matter? Are you and Ms. Gathright husband and wife? All right. Are you also trying to hire Heath High? All right, court's going to reset Mr. Gathright until July 13th at 9 a.m. for a status on hiring an attorney and also arraignment. Mr. Gathright, your bondsman has concerns with you. Your bondsman has concerns with you. Your bondsman has indicated to the court that they don't want to be your bondsman anymore. I don't lie to you, sir. Okay, so listen, so they filed what is called a release of surety, asking me to issue a warrant for you because you don't check in and you don't do what you're supposed to do. I'm just telling you what they say, okay? Well, hang on, that's okay. I don't want to hear from you. I'm going to tell you information, you listen. All right, so they sent that in and I signed it yesterday. And so there's a warrant for your arrest right now. All right. Now the bondsman has indicated that he wants to withdraw it, but he needs you to stay in contact with him. And so you need to contact him as soon as court's over. And if you don't keep your bondsman happy and comply with your contract and do all those other things that are between you and him, then he can ask this court to release him from your bond, which is going to issue a warrant and put you back in custody. All right. So there is a warrant for your arrest right now. I'm not going to execute it because your bondsman has asked me not to. But you need to be careful. If you get stopped between now and then and that warrant's not recalled, very likely you'll be going to jail because police officers will run your name and that warrant's going to pop up. So it might take a day or two for that to go away. So you need to be very careful, but you need to call your bondsman as soon as you get out of court. All right. And I want you to also come back here and meet with the pretrial release department, sign their paperwork, just like Jennifer did, and then you'll be free to go. All right. What's your name, sir? Okay, Mr. Weiner's still working on your case? Okay. And Reginald Young is still not here. Surprise, surprise. So Mr. Weiner still working on the David Schaefer plea state?
Yes, Judge, I do believe it is. I think they're swearing to that right now.
Okay.
I just ran out of
Okay, so he's gonna be a plea.
Yes, sir.
Ma'am, what's your name? Okay.
Something specific to unexecute or unreturn of warrant, just gave it to the clerk.
David Schaefer. CR 19-157-158. Yeah, CR 19-157 and 158. All right, Mr. Schaefer, if you'll raise your right hand, place you under oath. Mr. Schaefer, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can put your hand down. You are David Eugene Schaefer, is that correct? Mr. Schaefer, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Justin Weiner. Are you pleased with his representation of you? Do you feel like you've had enough time to talk with him about your case and have all your questions answered? Is there anything about the paperwork that you've signed today that you do not understand? And you're asking the court today to approve a plea agreement wherein you're going to be pleading guilty to a state jail felony offense of unlawful restraint of an individual less than 17 years of age in exchange for the state's recommendation that a finding of guilt be deferred on that charge and you being placed on 4 years community supervision with a $2,000 fine plus court costs and reimbursement fees. Is that what you're asking the court to approve today?
Yes, sir.
Mr. Weiner, do you believe Mr. Schaefer to be competent today?
I do, Judge.
And if you have explained to him his legal rights and also the advantages and disadvantages of the deferred plea?
I have, Judge, and just for purpose of record, this further was handled in this case first of the review. Both double check that this would not require any registration as a sex offender.
And it doesn't?
It does not.
All right, Mr. Schaefer, you're charged with that state jail felony offense of unlawful restraint of an individual less than 17 years of age. That carries a range of punishment if convicted of not less than 6 months or more than 2 years confinement in the state jail division of TDC and a fine not to exceed $10,000. What that means for you is if I approve this agreement today and place you on community supervision, if you violate the terms and conditions of your community supervision, the court could adjudicate your guilt. That means convict you of this offense, revoke your community supervision, and assess your punishment anywhere between 6 months and 2 years. You understand that? Understanding that full range of punishment, do you still wish to go forward with the plea?
Yes, sir.
How do you plead to that offense? All right, Mr. Schaefer, are you pleading guilty because you are guilty of committing that offense and for no other reason?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, court will accept the defendant's plea of guilt. Mr. Weiner, any objection to states one?
We know, Judge.
All right, states one's admitted into evidence and the court takes judicial notice of the defendant's judicial confession. Anything from the state with regards to victim notification and compliance?
Your Honor, I will review our patient file and see that, we should cover now, however, this was, prior to us switching systems, so it's very possible that it did, and we just don't have it in the new system. I also know that the victim in this case, in a different case, I know at one point she was institutionalized, so it may have been that victim notification wasn't possible at the time.
Which is institutionalized in multiple occasions or throughout the duration of my representation, Mr. Schaefer.
Does that mean mental health, TDC, mental health? Yes. court's reviewed the evidence and court will follow the plea agreement in this case and the state's recommendation. Court will defer a finding of guilt on the state jail felony offense of unlawful restraint of an individual less than 17 years of age. Court will place Mr. Schaefer on 4 years community supervision, assess, and order him to pay a $2,000 fine, $290 court cost, $40 reimbursement fee. Court will also dismiss cause number CR 19158.
First, that might have to from county staff, that we not, I will transfer to this, you know, not a problem. I'm instructing that they'll allow probation.
I'm gonna order him back there in just a moment. They can discuss it. All right, Mr. Schaefer, you hereby remanded to the custody of the Van Zant County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted with the bailiff, and then I want you to report to these officers over here about probation.
And then I would actually just retained on Mr. Curtis, Tony Curtis.
Okay. Ms. Abraham will assist you. All right, this is cause number CR 2388, Say versus Jonathan Rowland Goodjoint. We're set for docket call today. It's my understanding that the state's recommending Mr. Goodjoint for the pretrial intervention contract program. Is that right? Okay, so tell me what we're doing here.
Judge, this case was originally charged as. Digital stuff rejected. Such a manner that we decided by higher charge. Subsequently, Mr. Goodjoint hired someone. Smoothed out. What basis of the charges?
Well, I see that the original charge that you are moving to dismiss today is a bail jumping charge.
That's a separate charge. That is subsequent. We also believe was not necessarily fault. Originally charged as a perjury, then indicted as with tampering. Back on the original charge of perjury. He failed to appear for points we believe likely had lawyers that had previously.
I'll just add, Judge, I'm Mr. Goodjoint's third lawyer, his first retained lawyer. He had an initial attorney for the misdemeanor. Careful what I say here, but long story short, it ended up being a felony, so we got another lawyer. The FTA was during the out spoke to the state about the issues regarding this. And really what this took was somebody kind of pull all the pieces together and sit down and say for a good 30 minutes several times and iron everything out. And a lot of this, honestly, was very much blown out of proportion. So I believe this is a very fair solution, given the totality of the circumstances.
I'm not sure if it appears as though it's perjury is actually upstairs.
Yeah, that's what I was looking at it.
Bail jumping for whatever reason, it's like it's supposed to be downstairs. And never upstairs. So we have bail jumping up here, perjury is actually. So, Judge, if you feel comfortable hearing it, consider it a free trial. Just reset the. I'm comfortable with just dismissing the bail jumping here, waiting for a setting downstairs. If that's what works, what's necessary.
I mean, it's currently pending downstairs, right?
Yes, sir.
When's y'all's next docket down there? When's the next docket down there for this case? I see the last setting was on March 24th. Do y'all have a new setting?
I don't know if we have a setting on the misdemeanor judge. I don't think we have one.
Was it just?
I can see the last one's there for it.
So I've never seen any of this about it.
I'm unaware of Judge Winters here.
Concerned about like a conflict when you're a prosecutor or?
Well, it's his case and it hasn't been transferred up. So I mean, I probably have jurisdiction over it, but if he's going to be waiving some very important rights today for speedy trial, limited waiver of expunction, waiver of jury trial, if it's not in my court, I'd probably feel more comfortable either getting transferred up here and we do it, he signs off on it, or I'll let you do it all downstairs.
You want me to run downstairs and see if the winner is here, see if we get a transfer done real quick? Might as well. Long story short, it's a 12-month PCI that is hurry and said basically, as long as he's compliant within 6 months, they'll agree to an early discharge from PCI as well. So the sooner we can get the ball rolling, that's why I'm anxious to get it going. And I want to do it right without the judge, but the sooner we can get going there. If we can use briefly, they're going downstairs.
Yeah, and if you want to get it, if you want to get him to print an order, transferring it, then
Right.
we'll go forward.
Okay. You want to get him first?
Yes, let's take him up so that we're not keeping him any longer. All right, court calls, recall CR 2157, Say versus Tony Ray Curtis. Is Mr. Waddell available? Oh, that's okay. All right, Mr. Waddell, I've asked for your presence for an update on the administration of the urinalysis test that I ordered for Mr. Curtis.
Yes, the defendant gave a sample.
Can you come around here? So I can get you close to Miss Grisham and then scoot over here to where you're on the camera and back up. Back up. There you go. Go ahead.
The defendant gave a sample for testing, and the results of the test is that he's positive today for methamphetamines as well as marijuana. He did not want to validate by taking responsibility by signing a typical form that we ask defendants to sign, taking ownership of the results of the test.
I advise my clients not to admit it. Take the test, don't admit it, and secondly, incriminate. So that's on me, Judge. I advise all my clients never to do that. So no disrespect.
That's fine.
No.
Okay. You have any questions for Mr. Waddell?
I don't. Well, he was not on conditions of bond supervision conditions when he tested him, right?
Yes,
He was.
that was just 2 minutes ago.
Yeah, he was just serving his conditions right after the test. So I don't think he was on conditions of bond when he was ordered to take the drug test, Judge. But that's all I have to point out.
I believe that he was ordered. He may not have been aware of it, but he was ordered. The conditions of pretrial release were ordered prior to today.
Yes.
I don't
Just handed it, sir.
I don't think we received a copy of it
Right.
or seen it, Judge. Not saying that that's an excuse to know that, but it's just as a technicality, that's just my heart.
All right. Court is going to find Mr. Curtis's bond to be insufficient today for consuming illegal substances while on bond for an illegal substance charge. I'm going to find the $25,000 bail to be insufficient. I'm going to order Mr. Curtis into custody at this time, and we'll set new bail at $40,000.
and he says he'd be happy to just hear the PTI say that.
Perfect.
Paperwork.
Perfect.
We should hold the dismissal.
No, if you want me, I'll go ahead and dismiss it if that's what you want.
Yeah, go ahead.
We'll find out.
Judge Winters is here. He's ready to just hear it.
Oh, great.
So we can just take it downstairs, he'll sign it, put him on his pretrial, and we'll just be done with it. We don't have to worry about it.
Martin's kicking us out, I understand.
Yeah, I like it that way.
I'd be careful, he's still holding this.
Well, no, if that's gonna hold you over, I'll make sure. I sign.
See what happens.
No,
I can't.
no, I told probation, I'm referring to him on CDC, he's very serious about it.
All right, let's make my record real quick. On cause number CR 2388, State of Texas versus Jonathan Rolling Goodjoint, the state has tendered a motion to dismiss, which is part of a proposed plea agreement in the county court of law. So the court's going to sign the order dismissing the CR 2388. So Mr. Goodjoint, as far as I'm concerned in this court, then you are free to go. Here you go, Mr. Woodwright.
That's all I have.
Yes, sir.
Make some progress.
Made some progress.
Outside. Okay,
You just paperwork.
yeah. I'll get it straight. All right. So all the way down. See you later.
See.
Yes.
I'm gonna have him call names while she's busy. Oh, she did? Hey, Aaron, I'm sorry to interrupt you. Do you want me to have Mark come up, call names so you can continue with Mr. Curtis? I can. No, I don't want you to do it right now. I'm saying I can have him call it if you want.
I've got a transport coming, I'm just filling out. the
Okay.
paperwork.
Yeah, go ahead and do that then. That's fine.
This is a copy of the plea for this afternoon.
Okay.
This is the motion of the,
Yes.
yes, we don't need,
You know what? I do find the file is sufficient on us. Theft.
those are.
I can't read
I
what
know,
that
none of
is.
those were ours or theirs.
I mean, he got arrested for something else. I need to probably find his license.
We had him for.
His name wasn't on here. It was this guy.
He hasn't filed anything.
Name's not on there. What's that? What is that on the card right here?
TR 2390. Unless he just did. They didn't tell me.
No, he's been here before.
On her?
I don't know about on her. I've seen him here.
Oh.
I don't know, whoever it's gonna be.
Oh, yeah, they've got somebody. Oh, it has an error. That's why. See if you go to this little thing. Yep, it's got a data share error. Okay, I'll figure it out.
Okay, I am ready. Here, you mean just give me my docket?
Well,
I've got them circled out here. Beverly, it's all these nice sides.
Beverly, okay, I have
Beverly, Young,
right here.
Holly Mormon.
Yes, sir.
Wendy Jones.
Uh-huh. Is that it?
That's it. Here's, let me say this on the record. All right, Deputy, if you will call the names Nicholas Dubberly, Reginald Young, Holly Mormon, Wendy Jones. If you will call those names loudly and distinctly 3 times in the courthouse, if there's no response, the court will be issuing judgment nice size and forfeiting the bonds in those cases.
from me.
So there were no responses to any of those names called?
No response. Your Honor.
All right, court's going to issue judgment non-size and alias capias in each one of those cases. Court's going to stand in recess until 1:30, and we will resume